Welcome to a very special installment of Medmarc's webinar series as we celebrate Medmarc's 45th anniversary. 15 years ago, attorney Eric Zalud joined us as the inaugural risk management webinar presenter, speaking on a topic of great importance to the Medmarc audience, the product's liability risk created when sales reps enter an OR setting. Proving that as much as technology changes, many aspects of products liability risk in life sciences remain the same. Eric returns today with an update for us titled Sales Representatives in the OR, Navigating a Liability Minefield, a 15-year retrospective. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenter, Eric Zalud, thank you for joining us. Eric is a partner in the Cleveland office of Benesch, co-chair of the firm's Transportation and Logistics Practice Group, and vice chair of the Litigation Group. Eric has litigated or arbitrated matters in 33 states before state and federal trial and appellate courts in various jurisdictions, and before the Surface Transportation Board, the Department of Veterans Affairs, the United States Olympic Committee, the Better Business Bureau, the Federal Maritime Commission, and the Court of International Trade. Over the last 18 years, he has tried 35 cases, and his trial record is 31-4. In his litigation career, Eric has saved his clients over $14.9 billion in potential litigation exposure and risk through his litigation wins for them. Eric has an extensive medical device and pharmaceutical defense practice, and in 2002, he was named Medmarc's Medical Device Attorney of the Year. Overall, he has litigated over 100 product liability claims involving a variety of biotech and life sciences products. He also has a nationally renowned specialty in defending and analyzing the liability for component part and component supplier manufacturers under U.S. product liability statutes and common law, as well as extensive experience dealing with California's Prop 65 labeling requirements and litigation relating to those requirements, as well as dealing with FDA matters relating to personal health care and personal care products, and dealing with consumer and regulatory issues relating to several microbial germicide products. And with that, I am pleased to turn things over to Eric.
Thank you, Kate. Thanks for condensing the bio, too. Anyway, I didn't realize that I had presented the first webinar, but I guess it's all coming back to me now. 15 years, I mean, they say time flies. I don't think it went that fast. It's good to be back. And we took that PowerPoint from a decade and a half ago and vetted it very thoroughly to prepare for this webinar, made sure the cases were current, added newer case authority, consulted more current secondary sources for practical tips. So although the principles were there 15 years ago, this has been updated for today's world and today's legal arena. I saw some questions in advance, and I'll tell you that a lot of your questions will be covered by the content of the PowerPoint. I've always liked this area of medical device litigation. I've kind of been morbidly fascinated with it because, as you'll see, it kind of becomes the wild, wild west, and legal principles sometimes get cast aside, ones that would typically help the defendant as a result of the actions of the sales reps. So let's have a little bit of background. So sometimes reps must be in the OR to provide surgeons with technical support. They're part of a larger challenge in the OR. I call it crowd control, because when you look at the cases, and a lot of people attending have probably been in ORs in some capacity, there's a lot of people in there who aren't doctors or nurses, including several cases where the surgeon's children have been in the OR. And someone asked a question about R&D personnel. They are in there too on occasion, and a lot of these principles will apply to them throughout the PowerPoint. It's worth it to have them in there. There's a lot of amazing medical devices out there, and they get newer and better all the time and are constantly improving. So it's good to have the reps in there sometime to let the docs know about products with which they may not be familiar. But really what they should be doing is some baseline assessment, initially checking the device before surgery, things like that. A lot of companies provide training on these devices in advance of any surgical procedures, and even one-on-one consultations with the surgeons who are some of their best customers. What is the role of a sales rep? The nuts and bolts of it are focused on the component itself, right? The device itself, making sure that surgical instruments, any devices, prosthetic components are available to the surgeon and there and intact and complete. He or she should be familiar with the intended use of his or her device only, not other devices, and to answer questions that may come up from OR personnel. And these may relate to compatibility of the device to the procedure or the sequencing of the procedure for the surgeon. It's a cameo role, though. The OR is like a theater. It's like that old Seinfeld episode, speaking of 15 years ago. But reps are regularly dealing with the doctors and the hospital staff in a sales capacity. They're training the docs and the staff. They're very invested in the product, and I don't mean that in a negative way. I mean, they sometimes are invested financially in terms of commissions, but I've met with a lot of reps over the years, and they have a lot of them have a very emotional connection to the products that they are marketing and to those products' benefits. Many times they're on very good terms with the doctors, and they're invited into the OR. They try to be helpful, and they should, but let's all remember they are not doctors, and you'll see this in the case law. So a few cases that have lived on from my prior presentation and some new ones, all involving device reps. Zapola versus Leibinger, the plaintiff, a medical device case, sues Stryker, and also individually and separately its sales rep, a man named Brett Baird. And that's what happens in these cases many times. The company is named and also the rep is named as an individual. The doctor was a Dr. Swanee, I'm going to say. He was going to perform a craniotomy to remove a benign brain tumor, and lo and behold, sales rep Baird was present in the OR. And in the crux of the surgery, it became apparent that the bone flap had to be removed in order to get to a tumor, and it could not be replaced. And so the planned procedure required use of a rigid fixation system designed by Stryker. But as the surgery progressed, it became clear that the cranial opening, the opening in the skull, would need to be closed by some other means. So in the battleground of the surgery, the doctor consults with the sales rep in the OR, who then took a look at the patient's skull. And the aperture was 48 centimeters, which is pretty big. So the sales rep, in the heat of the surgery, suggests a different Stryker product called Bone Source, which you're going to love this. He obtained from his car. And in the parlance, they call that trunk inventory. So he went out to his car to get this Bone Source device. When he came back from the parking lot, he didn't tell the doc that the product was not Bone Source, wasn't indicated in the IFUs for use on openings more than 25 centimeters. And for openings of more than 4 centimeters, you should use wire mesh with it. And all this was suggested in the IFUs for the product, the instructions for use. So in the heat of surgery, the doc used this product, Bone Source, without reading the directions. A lot of times doctors are familiar with the products and they know the IFUs, but in this case, it was a new product. He did not read it. Plaintiff had issues. That's why we have the lawsuit, right? Leakage of cerebrospinal fluid that led to additional surgeries, permanent disfiguration, and damage. So the typical laundry list of product liability claims were alleged: failure to warn, defective design, negligence, negligent preparation, that's kind of a new one, negligent representation, and fraud. So those last three are kind of specific to this case. You don't see those very often. And the court said it was Baird's duty to make sure the product was properly used. It's one of the elements of a negligence claim is, did the defendant have a duty? And the court found that Stryker and Baird didn't adequately warn the doctor about this new product, Bone Source, and that negated the device company's protections under the learned intermediary doctrine, which could be a whole nother PowerPoint, but it essentially says that if the device company adequately warns the physician, the patient usually doesn't have a failure to warn claim. But here, the sales rep being in the OR and heading out to the car negated the protections of that doctrine for the device company. The device rep said that because the written instructions came with the product and the doc failed to read them, he should be liable. And as many people on this call know, often the doctor or the healthcare provider is a co-defendant in these cases. We never like to finger point, but they were doing a little finger pointing here. The court rejected that argument by the device company and said that the IFUs weren't sufficient because the rep was in the OR and should have informed the doctor that he wasn't properly applying the product. So not a good holding. Impact of the case. So I'm going to have a few of these throughout the presentation, but it's problematic, right? It's beneficial to have them in there, but it's fraught with problems. And, they're salespeople. So they can make grandiose representations, I call them, that can come by to bite them and the device company. Their conduct in the OR may supersede any written warnings or eliminate a very good doctrine for device companies, the learned intermediary doctrine. And remember, in these device cases, sometimes the failure to warn claim is the easiest claim to prove, easier than design defect or defective manufacture. There's also a risk of, if they get too involved, they could be found, and this wouldn't be in the lawsuit, but found to be engaging in the unauthorized practice of medicine, which could have penalties for them and maybe the device company. So it's good to instruct sales reps on informed consent. And as a lot of you on this call know, for most surgeries in most hospitals, there's many consent forms, a general consent form, and often specific consent forms for the specific procedure. We looked at a lot of them, and a lot of them do not mention reps at all. So there's no explicit consent for the reps to be in the OR. You can see here's one. These are from actual cases. It says who can be in there. Doctors in training, assistants, nurses, medical students, other students, PAs, operating room technicians. So reps are not specifically mentioned. Maybe we could argue that an OR technician could include that, but they're not clearly called out here. Here's another one. There may come a time when you would be eligible for such a study, but you are not alert enough to give consent. And so this patient signed the consent for the procedure and for a study. But again, no mention of sales reps in this consent form, although it's mostly about studies. You can barely see the highlight here, but this one I would say would be broad enough to encompass the reps. Individuals may be present as requested or permitted by your surgeon for clinical expertise. There's some good buzzwords, technical support, etc. Arguably, that consent form would include the reps. And these consent forms can be very valuable in device litigation. They can really help pare down claims. But that's the hospital's exemplar, right? So it's not the device companies. So it's important to have a consistent policy for the device company regarding rep conduct in the OR. Any consult with the physician, remember that the the doctor is the captain of the ship, and the rep should always defer to the doctor. And really, there really should not be any direct patient contact between the rep and the patient. That's fraught with liability risks. Sometimes it's better to even wait to even go into the OR until the patient is anesthetized. Another tip that might be hard in the heat of the operation, but try not to make suggestions by the reps unless the doc has the time to review the written warnings. And the rep should always recommend that the doctor review those warnings, and make sure to train the sales reps. Oh, yeah, and this is a good one. I got to laugh. And oh, of course, stay out of the trunk during surgery if you can. I don't think trunk inventory is a good idea. That's the bit of humor for this webinar. Another case that involved a sales rep and also the doctrine of preemption. There was a claim against Sitsick. I always mispronounce that. A sales rep for negligence in instructing, operating the physician on the use of this medical device. The court finds that that claim is not preempted by federal law. And preemption, I'm sure most people on this webinar know, is a very valuable doctrine in our toolkit, so losing it is not helpful. In this case, the plaintiff underwent surgery and the physician used a medical device called the NovaSure. And it wouldn't be in this PowerPoint if the defendant's sales rep wasn't in the OR, so he was in there and instructed the physician on the proper way to measure the size of Atkins' uterus and test the integrity of the uterine wall, which to me sounds perilously close to really getting too involved. The result of that exam indicated that the plaintiff, the patient, didn't have uterine perforations or uterine wall measuring less than 4 centimeters, both of which would have precluded use of the device. The patient suffered injury during the surgery from the NovaSure, and in fact, the measurements were less than 4 centimeters, contrary to what had been represented. The plaintiffs alleged negligent warnings or instruction to the surgeon by the sales rep. This is what often happens in these cases right here. The court granted the defendant's motion to dismiss almost all of the plaintiff's claims, except for one. It allowed the plaintiff to amend its complaint to allege specific facts relating to the plaintiff's claim for the sales rep's negligent warnings or instructions. So the whole case died, but the sales rep portion lived on. And the court's reasoning was that challenging the safety and effectiveness of NovaSure was preempted by federal law. And there's our landmark case, the Regal case. But the claims relating to the conduct of sales reps weren't preempted. And as I said, the case lived on, which we don't like. So case impact and recommendations. It's possible the federal law may not preempt negligence claims against the manufacturer for interactions between the rep and the physician during surgery. And the company and the rep himself or herself could be subject to just a straightforward common law negligence claim when, and this is quoting the court, when the rep is, quote, active as a de facto physician's assistant during surgery, end quote. You don't want to be that. So, you know, it's heated in there, and the reps have to be careful not to get too involved. And I'll have some even geographic tips later in this PowerPoint. Not to become part of the surgical team, and very careful about interacting with the physician during surgery. Never interact with the patient. And here's another procedural point. A lot of times sales reps claims may defeat federal court diversity jurisdiction, and we would always rather be in federal court. That's another problem. Another case, my old friend Aero International had a few cases for them. In this case, the doctor performed surgery on Ms. Walicki Gables, and implanting one of Arrow's traditional products, a pump and catheter in her spinal cord. You can see it right there, to treat chronic pain. The doctor implanted the pump. There was a rep, Greg Nelson, there in the room, and he's the one who had sold the pump to her physician, which is not unusual. After surgery, the pump malfunctioned. That's why we have a case, right? So the plaintiff consented to surgery to replace the pump, probably on a form similar to one of the ones we saw a few slides ago. This court probably looked at that form and it concluded she did not consent to the presence of people needed for technical support in the OR. So maybe one of those consent forms might have helped, but there's a lot that would not have. And the doctor had performed the surgery to remove the pump, replace the connector, take it out, and then put the same pump back in. Well, she had back problems, right? And a different doctor removed the pump, found a skin infection, and lo and behold, we had a lawsuit. The court granted the motion for summary judgment on the claim of negligence with regard to the rep participating in the operation to replace the pump. So this is a good holding, and it analyzed the actual schematics of the surgery pretty thoroughly and said that this rep did not take part in the decision-making during the operation to replace the pump. His role was limited to carrying backup products, hopefully not in his trunk. Here's a key fact that's a determiner too. He did not scrub in for the procedure. And this goes to one of the questions we got in advance. He did not enter the sterile field. So those factors were very important to this court to negate liability for the rep and the device company. They then alleged, the plaintiffs, that the rep had a duty to verify the patient's consent to his presence in the OR. Think about that. Think about the practicalities of that, right? And so thankfully the court rejected that claim. He did not know, the rep did not know that the patient hadn't consented, and he couldn't have seen for himself because of HIPAA privacy laws. So there's no way he could have known, and that was very important to the court. And the court further adds that this was a Florida case. Under Florida's consent statute, only actual medical practitioners could be liable for this type of claim. Now, the plaintiff in this case also claimed negligence based on the rep's participation in an off-label use of the pump, which could be another PowerPoint in and of itself, by providing the replacement connector rather than suggesting the replacement of the entire pump. So that was the decision-making or the action that this plaintiff claimed was actionable and was an off-label use. Again, rejected. So the hits keep coming, everybody. This is a very good case for device companies and sales reps. And the court found, although FDA regs do prohibit off-label promotion by manufacturers, there's not a private right of action for that. So the plaintiff can't bring that lawsuit. And in any event, they had no evidence of establishing promotion of off-label uses of the pump by Nelson. He was just in the OR outside of the surgical field. So another good holding in this case for device companies and for sales reps. Impact of this case. What factors do courts look at? And these are learning tools, right, for everyone. The extent of the actual interaction between the doc and the sales rep in the OR, whether the physician made his or her own decisions relating to procedures, and I say kind of tactical versus strategic. I would say the physician's decisions would be the strategic ones. Maybe the rep can assist in some tactical nuts and bolts decisions. The courts look at why the rep was in there, some of the factors we discussed, and whether the rep promoted off-label uses. More tips. So this is hard with salespeople, right? I mean, it's hard. but they should really discuss only information on the devices that's contained on the device's label and on their IFUs. And it's hard, but it shouldn't be. You know, there's a lot of info on those IFUs. But again, salespeople are nobly out there selling products, so you never know. And of course, kind of obvious, but a rep shouldn't suggest that the doc or even imply that the doctor used the device in a way that's not stated on the label. An extreme example would be overt disregard of the IFUs, not using a guide wire, as I think was one of the cases. That's why I have guide wire there. So common sense, it seems like, but you never know. Another case involving the learned intermediary doctrine, Western District of Oklahoma. Plaintiff had his hip replaced with a Biomet hip. And then after the replacement, he suffered 11 hip dislocations within a period of weeks. So that's a lot. And the doctor who performed the surgery was Dr. Tompkins. He noted the Biomet hip dislocation easily only during flexion to 80 to 90 degrees with moderate adduction, 30 degrees of inward rotation and axial loading, which rotation plaintiff was not warned not to do. So not abnormal. The plaintiff had also fallen, injured ligaments in place before the first dislocation. And of course, that would have made those subsequent dislocations more likely, the other 10 dislocations, which is still a lot. Anyway, so a lawsuit results, and the plaintiff claims design and manufacturing defect. Hard to prove, right? And the court concludes those claims they cannot survive for a design defect. They have to go into alternate feasible designs and expert witnesses. For a manufacturing defect, they have to prove this particular lot somehow diverged from the manufacturing process. Those are harder to prove. The much easier cause of action in these cases to prove is failure to warn. That's virtually always where we see the sales reps come into play. So there's alleged failure to warn that it could dislocate so many times. And also there was a sales rep, Biomet rep, in the OR for the surgery. And that rep should have warned either the patient or the doctor, was the allegation, about the quote unquote, this is from the case quoting the plaintiff, the hidden dangers or the possibility that the implant had a damaged acetabular cup. So that seems weak, right? Let's see what happened. So the plaintiff alleges that the sales rep breached the duty of care because he should have advised a physician on what type and size of components and suggested maybe a different implant might be more suitable. And this is another good holding. Found no evidence that there was any duty, and that's important. There was not a duty. That's a critical component of a negligence claim, to advise the doc in the OR at this level, and therefore no breach because there was no duty. And sometimes if you say too much, you can gratuitously assume a duty, but the court found that the rep didn't volunteer any advice and therefore assume an additional duty that he breached. So no duty and no breach, no gratuitous duty and no breach. So a good holding. So the court found that Biomet, not surprisingly, did provide FDA-approved warnings to Tompkins through his, it should be his, not his, physician. So a classic case of the learned intermediary doctrine. In those cases where this doctrine applies, the device manufacturer has no duty to provide additional warnings to the patient. Even if the warnings could be considered inadequate, Biomet would not be liable because the failure to warn didn't result in plaintiff's injuries. and the plaintiff was warned before and after surgery of the likelihood of dislocation if precautions were not taken to minimize risk. And therefore, this broad warning, even with the rep in there, was adequate under the learned intermediary doctrine to prevent liability as to the device manufacturer for failure to warn. So some lessons from this case, if a warning or IFUs, even if relatively general but inclusive, and especially FDA approved, which most of them are, is included with medical devices, and they almost are, right? The learned intermediary doctrine is a very good protection against device manufacturers in failure to warn cases. I've won a few summary judgments on those. And more tips that you're starting to hear again. I've mentioned them before. If the sales rep's in there, make sure they're interacting with the physician and not the patient. And direct any warnings, the rep should, to the physician, and avoid, if possible, again, this is hard for salespeople in the crux of surgery, avoid the appearance of volunteering information, because that could create a duty that could be breached and also lead to liability for the manufacturer. To keep that learned intermediary status, it's best for device companies to target marketing to medical professionals rather than directly to the customers or patients. Again, this could be another PowerPoint, right? Because we have all the ads on TV these days, but obviously follow all FDA advertising regs. That will help in these cases, obviously, and it really helps with the learned intermediary doctrine getting out of cases. Good, we're moving right along. A few snippets here from other cases, the lightning round. Here's a case, Massachusetts, where they found that the physician's misuse of the device standing alone was insufficient to establish that the manufacturer breached the duty to the plaintiff. And it's less clear from the court where if the manufacturer would have done more to certify the physician, whether there would be liability, but there was not. Good holding for device defendants. A Texas case, plaintiff brings suit against a device manufacturer and sales rep for injuries during a hip replacement. And the rep had taken some action here, some more nuts and bolts, right? I don't know if it was a he or she, but it positioned equipment and assisted the scrub nurse in preparing equipment. I'd say borderline, but focused on the device and the equipment, and assistance to the scrub nurse is one step removed from assistance to the doc. So all good factors, and the court agreed. Kennedy versus Medtronic, another good holding. The rep did not voluntarily assume the duty of care by providing technical support and calibrating a cardiac lead before surgery. So again, these are some of the watchwords, right? This rep was in there, but only providing quote unquote technical support. And it looks like he or she was focused on the device itself, the cardiac lead. This rep had assisted with 15 similar insertion surgeries per week. So, you know, a lot of them are in there a lot, depending on the device. But the court properly determined that the rep couldn't make the medical judgment about whether the lead was inserted correctly. And an excellent holding by taking on a limited emphasis on the technical role. The manufacturer did not owe a duty to the patient to ensure, you know, the medical procedure that the lead was correctly placed into the patient's heart. Again, I say tactical versus strategic, right? This rep assisted with tactical aspects, technical support related to the device itself. Here's another little twist. The court found that by verbally reassuring the patient before surgery, the rep didn't assume a duty to ensure patient safety during the procedure. I mean, that is fraught with peril in my view. I don't think there should be any, and not just me, it's the cases. Direct contact by the rep with the patient, especially in close proximity to surgery, is a liability risk. Just a little morsel on duty to train, slightly off topic, but I happened upon these cases. And there's no, manufacturers generally don't owe a duty to train physicians. There's some wrinkles to that, but here is a couple good cases for that proposition. It's a lightning round, so that's all I'm going to say on that. And as I said earlier, here's a case where it dealt with other issues on a statute of limitation, but this court in dicta, wasn't a finding of the court, but it says that the rep's conduct was very close to the practice of medicine. Plaintiff alleged facts in good faith that raised serious questions regarding the propriety of sales representatives in the operating room, the gravity of plaintiff's allegation that a sales rep performed or participated in tumor abulation procedure is not lost on this court. So it's scary dicta, and that's all the more reason to be careful and vigilant. And this is the court's term. It found no, quote, quasi-physician-patient relationship, which is a good fighting in spite of the dicta from the court. Here's some tips for hospitals, and these are from cases I've been through, doctors I've talked to, and from some trade press of late. But if this is possible, it's good to designate an area where the rep should wait until it's time for surgery. Shouldn't be the physician's lounge where they can have contact. Reps should wear badges, different color scrubs. A lot of times there are hospitals that have black. These are some examples I'm aware of: fuchsia or jailhouse orange, so people can tell who the reps are in the surgical theater. Always scrub in and stay out of the OR until the patient's been draped, and if possible, even anesthetize. Some hospitals require proof of certain tests of communicable diseases and questionnaires. And you don't want the vendor reps knowing who's in the hospital. That's what a hospital compliance officer told me, I think. It's really recommended the rep not even know the name of the patient on the table in their OR, or some way to prevent the rep from writing down the patient's name. Helps with liability, some tension with MDR reporting. And some hospitals require the reps to sign an advance statement about hospitals' privacy and security policy. I think most of them do now. Here's some policies that device companies might consider for their reps. Wear a name tag during the procedure unless that's prohibited by the hospital. That goes to making sure they're clearly identified. Confirm where to stand during the procedure, before the procedure. Obviously, comply with operating room decorum and other hospital policies, so it's important to know what those are. It's foolhardy for a rep to ever touch the patient. They shouldn't enter the sterile field or even the semi-sterile field. An obvious one, but this is what this is what causes the lawsuits. Don't offer opinions on diagnosis and treatment of any condition or person. So in other words, not the strategic, the tactical, not the strategic. Don't promote off-label use of a product. We've talked about that. Here's some actual testimony from a sales rep's depot. And I think this is from a case where the rep had not been brought in yet, and I was defending the deposition to keep him out. And they asked, where did you stand when you were in the room? I don't think we were at the head of the table. There were several people in the OR. There were, I think, some perfusion students. It was a pretty crowded OR. We stood kind of to the side, but I don't remember specifically where we stood. I told you they could be crowded. What was the reason for you to be in the room? To be in the OR was a good opportunity to be around a surgeon during a procedure. Secondly, we wanted to get his feedback after using this product. We often wait until the surgeon has gone, completed the procedure. We like to find out his thoughts, comments, discuss what he thought about the product. So this is all very safe, right? Near the surgeon, but really not involving oneself in the procedure much at all, but wanting to get feedback after the procedure. Were you in the room to offer guidance or instruction to the doctor on the use of the ADE? No. So we love that answer. Did you offer guidance or instruction in the OR room to the doctor? No. Were you able to visualize the operative field from where you were standing in the OR room? Not really. So couldn't even see the operative field. Were you able to watch the procedure on a monitor or an echo stream? I don't think so. So this is a dream deposition transcript, and of course, the facts themselves have to be good, but here they were good. Seems like good policies. This company was not dragged into that litigation. Since we're 15 years ago, I'm going back to a little, I gotta believe a chunk of the audience remembers David Letterman, right? Most of the audience, but let's sum it up and close out by top 10 tips for minimizing liability in the OR. This was a famous one. I think Letterman actually did this one. Number 10, reps should stay out of the ambit of the sterile field, and any actual assistance should be rudimentary and mundane. Example, handing a nurse something. Tactical versus strategic, never touch the patient. Number 9, they should have the means to be very clear, verbally and visually identify themselves as sales reps and not healthcare personnel. And like we mentioned before, scrubs, badges, verbal ID. Number 8, confine any consult in the OR to matters specifically relating to the device. That shouldn't be hard, but sometimes it is. Number 7, have training programs by the reps for the surgeons before the actual surgery with demonstrations, feedback, Q&A, as opposed to during the surgery, right? Number 6, in the OR, don't give training instructions to surgeons that contravene the IFUs, I'm sorry. And the problem is if a surgeon consciously disregards, but the rep will have done his or her best. Number 5, minimize, and I stress this a lot because it's important and it's an easy one, or eliminate all direct patient contact, wait until anesthetized, avoid personal knowledge of the patient, use a different system to track the surgery. Number 4, interface with hospitals, and this could be done for inclusion of sales rep language in the patient-informed consent forms that we looked at. It would take a little effort, but those consent forms can be revised, and hospitals are malleable on that point. Some of them anyway. Number 3, this is an important one, just background, have a written policy for sales reps conduct in the OR. Number 2, enforce and abide by the policy and document that. Now, what I mean by that is, number 1, have the policy, all right? Number 2, comply with the policy. And number 3, document that you're complying with it. The worst thing for a products case or other cases is for a company to have a policy and not comply with it. You get into punitive damage territory there. So that's the tripartite requirement for number 2. And number 1, train the reps. A lot of these issues in these cases could be circumvented by good training of the reps, at least annual in-house seminars, and it does sink in. It does sink in. So that's the top 10. One last couple slides. This is a buzzword that could win your case. We see it used in a lot of the cases, and it's the vernacular of a lot of surgeons. So this is from an actual surgeon's quote in a case that was won for the device manufacturer. Well, it is my strong belief that the patient has a contract with the physician. The physician has to take responsibility for everything that occurs there. I am old-fashioned in that I believe the surgeon is the captain of the ship. So regardless of what happens, the surgeon has a certain degree of responsibility. So that's accurate. That's great language that can help win your case. And one last slide about a case where that was used. Sales rep delivers a fixator to the OR. The doctor applies the fixator to the bone with bone screws. The drill bit of the bone screw pierces the radial nerve, causing permanent damage. The court applied the captain of the ship doctrine in the negligence claim to all persons in the OR, including those that did not work for the hospital, i.e. the sales rep. So excellent buzzwords to remember in briefing, in depot questioning. They can save your case and get the device rep and manufacturer out of the case. 10 minutes left, Heather. I don't know if there's any questions, or was that just a lot of content? I think I covered most of the questions that were listed.
That was some great content, Eric. Thank you so much for your time. Really appreciate it. We have had a couple of questions come in. One is asking if you could talk a little bit more about why trunk stock could be problematic. They state that one of the benefits of having a sales rep in the OR is that if a device breaks or it's dropped, if they need a replacement for some reason, the rep is able to go get that out of their trunk stock. So what is the problem with that?
Yeah, it's funny. The last time I gave this presentation, it was either the webinar or DRI. Someone asked the same question, and I said the same. I probably said the same thing. I understand that's part of the exigencies of how device reps roll and conduct business. To me, so I get it. I mean, maybe sometimes it has to be done. To me, just the whole process of leaving the OR during surgery, running out, becoming unsterilized, running back in, that seems like it's fraught with risk. You probably know better than I do, of course, on the procedures. And when litigating a case, the optics of that to a jury or maybe even a judge don't look that good, in my opinion. So I get it that sometimes it's got to be done, but that's just my take on why it could be a little bit problematic in litigation.
Is it maybe preferable for the rep if they prepare in advance, maybe bring extras to the room, to the OR with them so that they're not having to leave the space during the procedure?
No, good question. I mean, so much of this jurisprudence is, nuts and bolts, actual physical geography. So combined with another word you mentioned, preparation. So the more preparation, the better. More preparation for other possible variables in the surgery, the more accessible, and then you combine that with geography, the more accessible other alternate components might be. I just think, that helps in defending the case, I think.
We have another question. What happens when the record is unclear with regard to whether a surgeon received the appropriate warnings? If the rep is saying, yes, I warned the surgeon states that that's not the case, how is that resolved?
Well, the lawyers on the call will know that sounds like you're not going to get summary judgment for the device manufacturer rep in that case. So, I mean, there are cases where there are disagreements, and maybe that's too strong a word, but differing recollections of procedures in the OR by people who were in there. And they might be, honest recollections, differing recollections from different perceptions. And, the way to try to solve that from a litigation perspective would be any type of corroboration we could get for the rep's version of what happened, documents, videos, recordings, who knows, other witnesses. So that would be the way to do it from a litigation perspective. But, if you got the doc saying one thing and the sales rep saying another as to a critical issue of fact, that's a case that probably would have ultimately go to the jury, and they'd have to make an inferential leap about maybe not who they believe, but whose recollection sounds the most realistic in the circumstances.
We do have another question as well. And this is something that we've encountered at Medmarc and working with some of our policyholders. Can you talk a bit about sales reps who are also licensed healthcare professionals? Are they held to a different standard than an unlicensed sales rep?
Yeah, I mean, a lot of these cases they weren't, so I know that's an evolving trend. And what I can tell you what I've learned from reviewing the cases is that sales reps who also have some, healthcare related certification of some kind would be held to some different standard. Is it enough to drag in the device manufacturer for liability? Maybe not, but based on all the cases I've looked at, that would be a higher standard, or there might be two separate standards.
Yeah, it's also a real challenge. Sorry, it's also a real challenge for those reps we've heard in cases or examples of trainings or discussions we've had with them for them to really focus on taking off that provider hat and making sure that they're operating as a sales rep rather than a healthcare provider.
It's hard. I mean, they have to. I mean, my advice would be to, not get involved with healthcare treatment decisions if there is a captain of the ship, so to speak, and try to keep those hats separate if possible. Another reason maybe for the simple process of wearing a badge or a different colored surgical gown. But yeah, it's human nature, right? I think it's hard to separate, but it's helpful if they do try to separate.
Is there any difference in the risk when you're talking about an independent sales rep, a 1099 versus a direct employee of a device manufacturer?
Yeah, I mean, I have to put on my labor and employment hat, and I don't have one of those. But I would think that under principles of agency, if the rep was a 1099 contractor, I'll call it, of the device company, principles of agency would probably apply and could drag the device manufacturer in. All the same tips I gave throughout this PowerPoint would apply, obviously.
Thank you. We are coming up on the hour. Thank you so much for your time today. This is really valuable information. And as you can tell from the discussion, our audience was really engaged. So thank you so much for your time and expertise. Thank you for joining us. This concludes today's webinar.